Alright, ladies and gentlemen, welcome to my YouTube channel. The last time we did introduction to criminal litigation, and I say that today we will start with the main gamut of everything that criminal litigation starts with. Of course, you know that when we talk about criminal litigation, in fact, every course you'll be doing in Nigerian law school, all the courses is like a journey. It talks about a journey from when anything starts to when that particular angle of law ends. Now, for example, in criminal litigation, we got to know that, of course, it starts with you committing an offense. If you commit an offense, of course, the criminal law would be set in motion against you. And it starts with investigation. After investigation, you are being arrested. After being arrested, you are being charged to court. After being charged to court, of course, the whole burden of proof would have to be offset by the prosecution, because, of course, the burden of proof is on the prosecution. And you know, if you are about to go to law school, you know that the burden of proof is on the prosecution to prove based on the standard of proof. And what is the standard of proof? Beyond reasonable doubt. Now, if the prosecution offsets that burden of proof, it's now left for the defense, that is the accused, of course we don't call them accused like I said, the defendant, to disprove or to put a little doubt in the mind of the judge. So when that happens, the accused is either convicted or exculpated. If he's convicted, the accused will be sentenced accordingly. If it's death, if it's pre-imprisonment, if it's fine, the punishment takes its course. If he's been exculpated, that means he's found not guilty. Of course, he will be discharged and acquitted. And if the other person is not happy with the decision, the person can now go on appeal. And when the appeal is being determined, of course, you can still probably go on another appeal till it reaches the Supreme Court. And when the Supreme Court reaches its own decision, then it is final. So we are taking you on a journey from the first thing that happens to the last thing that would happen in criminal litigation. And so we are in arrest, searches, warrants, etc. So what happens when you commit an offense? Of course, ordinarily it's supposed to be investigation first. But most of the times you would see that you are being arrested first before investigation. And the reason it should have been investigation first is because based on our constitution, section 35, if you read it through, I think subsection 4 and 5, it says that if you arrest somebody, you are expected to bring the person to court, to charge the person to court within reasonable time. And it gave the definition of what reasonable time is, which is 24 hours if there is court within 40 kilometers radius, and 48 hours if there is no court within 40 kilometers radius. Now tell me, if you arrest somebody first before going to investigate the person's offense, how is it possible that you would finish that investigation within 24 hours in order to charge the person in court within that 24 hours? So you now see how logical it is for investigation to take place first before arrest. However, we are not here to make arguments. We are here to learn about arrests, searches, and we also talk about your constitutional rights when you are being arrested. Now, first of all, we'll start with searches. What is a search? A search is an examination of a person's body, premises, or thing, which the person would reasonably be expected to consider as private, provided that such an examination is conducted by an authorized officer of the law for the purpose of finding evidence for the possible prosecution of a crime. So it tells you the things. This definition is very sweet because it tells you the things that are prone to be searched. It talks about the person's body, the premises, and a thing. So search can either be of a person's body, of a premises, or of a thing. We will explain this. It also tells you the purpose for which searches are conducted. Now, you conduct searches for the purpose of finding evidence for possible prosecution of a crime. So if you are conducting a search that does not have the purpose of finding evidence for the possible prosecution of a crime, then you cannot say that you are conducting a search under criminal litigation. So we will take it one after the other. Search of a person, search of a premises, and search of things. Now, the following should be noted under search of a person. Now, I used to see many people talk about if police wants to search you, you now want to claim that you know your right. The right that you don't know, you're claiming you know it. You now be asking the police you must have to show me a search warrant. You'll be posted. You must have to show me a search warrant. If you don't show me a search warrant, you cannot search me. And you bring out your video and you're making videos and saying that this police doesn't want to show me a search warrant and he wants to search me. If a search is on a person, search warrant is not needed. Search warrant is not needed. Why is it not needed? Because ordinarily, if they want to search you, it is usually under suspicion. And the law is very clear. The police can even arrest you based on reasonable suspicion. You do not need to even commit any offense. If the police has looked at you and reasonably suspects that this guy, you look like a criminal, they can carry you, they can arrest you. So it is based on suspicion. Now let us assume that I suspect that you are carrying, let's say, drugs in your bag. Of course, there are ways or there are processes by which warrants are gotten. So if I suspect that you carry drugs and you are passing, will I now leave you and go and write information on oath to the judge or magistrate in order to obtain a search warrant before coming back to search you? It will be stupid now. It will be illogical. So search warrants are not needed for searches on persons. You do not need search warrants to search a person. You can see that in section 9, subsection 1 of the Administration of Criminal Justice Act, section 5, subsection 1 of the Administration of Criminal Justice Law, Lagos, and section 32, subsection 1 of the Administration of Criminal Justice Law, Kano. Searches on a person can be done before or after arrest, depending. Yeah? If a search is conducted, the police officer shall place in safe custody every article that has been recovered from the search, the person search, except his necessary wearing apparel. So everything that is being gotten from you when you are being searched would be placed in safe custody, except what you are wearing. Of course, you will not be naked now. All those things that are placed in safe custody, inventory will be taken of them, and the copy of that inventory would be given to the suspect or his lawyer, or such that person has been directed by the suspect. So if I finish searching you, the list of the things that were collected from you would be written down and will be given either to you or to your lawyer, depending on who is defending you. So another point to note is that when it is necessary to search a person, such a person shall be searched by a person of same sex. If it is necessary for a person to be searched, that person must be searched by a person of same sex with due regard to decency. That means a man is to be searched by a man and a woman is to be searched by a woman. However, we all know that there are some circumstances wherein it is the urgency of the matter would not really give so much latitude of time in order to get a woman to probably search a woman. So in that circumstance, of course, an opposite sex can search but there must be the urgency that if I don't search this person here and now, something will spoil. You understand? If not, you can just quickly arrest the person and take the person to the station where a female police officer can search the woman. So male must search male unless the situation requires that urgently you must search. So that is according to section 9 subsection 3 and section 149 subsection 3 of the Administration of Criminal Justice Act. We have section 5 subsection 2 and section 109 subsection 3 of the Administration of Criminal Justice Law, and we have of Lagos. We have section 32 subsection 3 and section 159 subsection 3 of the Administration of Criminal Justice Law, Kano. Then we have section 51 subsection 6A of the Police Act 2020. So when you look at section 53, you would see grounds which do not come under reasonable suspicion. For example, I told you that a police officer can look at you and think and have the suspicion that you are a criminal and arrest you. Yeah? But section 53 is saying where the ground will not work. And if you look at section 53 of the Police Act, it's Police Act I'm talking about, you would see that the police should not have reasonable suspicion when you are dressed in a certain way. Or maybe you have dada, for example, dreadlocks, and you open your ear. Most of the times the police people will just start telling you that you're a Yahoo boy. So section 53 is saying that the police is wrong for doing that, because how somebody dresses and a stereotype. Just go and read section 53 of the Police Act, so that at least if the police is trying to tell you that you're a Yahoo boy because you have dada and you have earrings on as a guy, then you can tell them that please, you cannot be saying that to me, because of course, even if it's like you don't read your laws. Because in your law, section 53 of the Police Act says that you cannot use my way of dressing to judge whether or not I've committed an offense. If you think that I've committed an offense, then with your evidence, you can now charge me to court. Don't be telling me that I'm a Yahoo boy, because that is a defamation of character. You know, when you speak something like this, the police people will now go back and say, oh, nah, this one is bad meat, so this one knows he's right. All right. Okay, sorry, not section 53, section 54. I'm sorry, section 54 of the Police Act. So section 53 is talking about intimate search. So please make that correction. So we now go into search of premises. Now, as a general rule, search of premises, you need search warrant. Yes, it is when they want to search your premises that you would need search warrant. So you do not need search warrant for search of persons. It is only when you want to search the premises of a person that you would have to present search warrant. No search is to be conducted on a premises if there is no search warrant. As a general rule, no search is to be conducted in a premises if there are no search warrant. But there are exceptions. The exceptions are, if a police officer, number one, is acting on a warrant of arrest and he wants to arrest somebody, even though he's not acting on a warrant of arrest, he's chasing somebody to arrest somebody, and the person runs into your premises, the police officer can enter your premises to search for the person, even without a search warrant. I'm talking about the exceptions of where the general rule states that you must have to search a place or a premises with a search warrant. So when a police officer is trying to arrest someone, maybe acting under an arrest warrant, or probably not acting under an arrest warrant, but of course is chasing somebody to arrest the person, and the person enters your premises, the police officer has the right to enter that premises and search even without search warrant. Because look at it. For example, what if the police officer must need a search warrant to enter there? That means before you must have gone to the judge to write your information on oath in order to get a search warrant to search your house to bring out the criminal that entered into your house. The criminal must have left. So that is an exception to having a search warrant compulsorily before you enter into any place to search. And that you can see in section 12, sub 1 of the Administration of Criminal Justice Act, section 7, sub 1 of the Administration of Criminal Justice Law, Lagos, section 35, sub 1 of the Administration of Criminal Justice Law, Kano, and section 55, sub 1 of the Police Act 2020. Remember that we are looking at Kano ACJL and Lagos ACJL based on what is obtainable in the north and in the south respectively. Then we have our AGJA, Abuja FCT, national courts like Federal High Court and National Industrial Court. So if you don't know what I'm talking about, please watch the first video on Introduction to Criminal Litigation so that you would get the legal framework of what we are doing. So another exception is when there is a presence of a magistrate or a justice of peace. So if there is a presence of a magistrate where they want to search you, the presence of the magistrate in that premises where they want to search is enough search warrant. So you wouldn't need any other search warrant from any other magistrate or any judge in order to search that particular place that the presence of the magistrate is there. The magistrate is already there. So the presence of the magistrate is enough search warrant. A custom officer may enter or break into any place where he reasonably believes that illegally imported goods are kept. So if a custom officer knows that this particular place, this particular house, there are a lot of illegally imported goods, he doesn't need to go back to get search warrant in order to come into that place to search. The law has given them the powers or the responsibility to enter into this house and search, especially when they reasonably believe that there are illegally imported goods. You will see that in section 147 of the Customs and Excise Management Act. An officer of the NDLEA, another exception, where you do not need a search warrant to search a building. An officer of the NDLEA or police officer, in order to recover drugs kept in premises, may enter and search such premises without search warrant. So an officer of the NDLEA has reasonably suspected that there are drugs inside this place. The officer of the NDLEA or even the police officer, with that reasonable suspicion, can enter into that premises to search for drugs without a search warrant. Remember, we are talking about the exceptions of where you would not need a search warrant. You know, the general rule is that you must have a search warrant before searching a place. But we're talking about the exceptions where you do not need a search warrant to search a place. So that when they come to your house to search, you would have to use your brain to look at, are these people under the exception in order for them not to show me a search warrant? If you now go through all these things that I'm telling you now, and you see that it does not come under any of these, you now ask for your search warrant. But if it doesn't come under all these things, if they don't have any search warrant, you will not go and be fighting with them. You allow them to search, but you still have to sue. Fundamental rights action. So the NDLEA exception is, you see it in section 41, subsection 1, paragraph B, subparagraph I of the NDLEA Act. Another exception is order of court. Acting upon an order of court, of course, order of court is already enough warrant now. If court gives order, you would not need another search warrant in order to search the building or the place. Now, the Nigerian Security and Defense Corps, they do not need a search warrant to enter into a premises where it is reasonably believed that government property is being unlawfully harbored. So you have stolen street lights that was supposed to be for public good and public use. You now carry the street light and you put inside your house with the hope that you will sell the street lights. And somehow, you had a snitch that snitched on you to the Civil Defense Corps. The Civil Defense, they will come to your house and they will knock. And when you open the door, they will tell you that they're here to search your building. You cannot now tell them that they should go and get your search warrant. No, because the law has empowered them that when they reasonably believe that a government property is being harbored in a particular premises, they can come into that premises and they will search, and they would not even bother about giving you or even obtaining a search warrant. So that is in section 3, subsection 1 to 3 of the Nigerian Security and Civil Defense Amendment Act. Now, who can issue a search warrant? There are 3 categories of people that can issue a search warrant. We have the magistrate, the judge, and the justice of peace. Now, I just mentioned 3 people: magistrate, judge, justice of peace. Did you see where I mentioned a senior officer of the police force? No, I did not mention it. Because they will come to you with this thing in your exam. A senior police officer has issued a search warrant. Comment on the validity or otherwise of that search warrant. It is not valid. It was in the old Police Act that it was valid. But in this new Police Act and in our new jurisprudence, a police officer, no matter the rank, even the IGP himself, cannot issue a search warrant. The IGP cannot issue a search warrant. The Oga Patapata of them all, the president, who is the commander-in-chief of the armed forces, cannot issue a search warrant. The people that I've told you that can issue a search warrant is the magistrate, the judge, and the justice of peace. In fact, under the Administration of Criminal Justice Act, Section 144 and Section 146 of the Administration of Criminal Justice Act are to the effect that a judge, magistrate, or justice of peace may issue a search warrant. It's under the ACJA that the 3 of them complete can issue the search warrant. Yeah? In Lagos, under Administration of Criminal Justice Law of Lagos, listen, Section 104 and Section 106 of the Administration of Criminal Justice Law of Lagos, a magistrate is permitted to issue a search warrant. So it did not say anything about a judge or a justice of peace. However, under the Administration of Criminal Justice Law, Kano, it says a magistrate or a judge can issue a search warrant. It did not say anything about justice of peace. So you must have to know these things. Administration of Criminal Justice Law Lagos says that it is a magistrate. It did not make mention of a judge or a justice of peace. The one of Kano said judge or magistrate. It did not make mention of justice of peace. So they can come in the exam and tell you that in Lagos, a justice of peace issued a search warrant. Comment on the validity or otherwise of the search warrant. And in your head, because you have heard, in your head, because you have heard, and in your head, because you have heard that it is the magistrate, judge, and justice of peace that can issue a search warrant, you will now say that the search warrant issued by a justice of peace in Lagos is valid. It is not valid though, because in Lagos, section 104 and 106, if you read this well, you would see that there is no place they mention justice of peace, and we follow the law strictly in law school. All right, note these things about a search warrant. Number 1, every search warrant issued must be signed by a magistrate or other issuing authority that issues it. Yeah, you look for the section 146 sub 1 of the ACJA. You see it in section 106 sub 1 of the Administration of Criminal Justice Law Lagos, and you see it in section 156 sub 1 of the Administration of Criminal Justice Law Kano. It must be signed by the magistrate or any other issuing authority that is issuing it. So it must be signed. If it is not signed, it is a problem. Every search warrant shall remain in force until it is either executed or cancelled by the court. So what is the duration of a search warrant? It is subsisting until it is executed. Now, if it is executed, it cannot be reused. Let's say, for example, you've searched a premises. You cannot carry that same search warrant and come to research the premises again. You have to go and collect another search warrant to search the premises again. That is in section 146 sub 2, Administration of Criminal Justice Act, section 106 sub 2 of the ACJL Lagos, and section 156 sub 2 of the ACJL Kano. So on demand by the police officer or anybody that's coming to search, the person, the owner or the occupier of the place that they want to search, must give them the necessary facilities to search. What do I mean? You must not block the police officer or the people that are coming to search from searching, especially when they have a search warrant. In fact, even though they don't have a search warrant and they come under the exceptions of people that don't need the search warrant, they are supposed to be given free ingress and egress in order to search that place. Failure to do that, the police officer or anybody that is coming to search is free to break into the house. But if you are breaking into the house, just make sure that there is no dog in the house. Because breaking into the house might be breaking into your doom. So you see that in section 149 sub 2 of the ACJA, Administration of Criminal Justice Act, section 109 sub 2 of the ACJL Lagos, section 159 sub 2 of the ACJL Kano. Under the case of Musa Saudu against the state, the court held, unless the court otherwise directs, the search made pursuant to a search warrant, that is, the execution of a search warrant, must be conducted whenever possible in the presence of two respectable inhabitants of the neighborhood, to be summoned by the person to whom the warrant is addressed. So, two respectable persons. There should be like two witnesses that will witness the search when the search is being executed. So that's Sadao against the state. So you look at section 149 sub 4 of the Administration of Criminal Justice Act and section 159 sub 4 of the Administration of Criminal Justice Law, Kano State. If a place to be searched is in the actual occupation of a woman, not being a person to be arrested, who according to customs does not appear in public, so we have women in Puda, the person making the search shall, before entering the apartment, give notice to such woman that she is at liberty to withdraw and shall afford her every reasonable facility for withdrawing, and may then enter the apartment. If a woman in Puda, that does not appear in public and people don't usually see, if the woman is in a particular premises where the search warrant is to be executed, notice must have to be given to those women or that woman in Puda in order to withdraw from that place before the search people come. But then, notice will not be given to her to withdraw if she is the person that they want to arrest. What would happen is that the person that will now conduct the search and possibly arrest the woman in Puda should be a woman. Look at that in section 12 subsection 3 and section 149 subsection 6 of the Administration of Criminal Justice Act, section 7 subsection 3 of the ACJL Lagos, and section 35 subsection 3 of the ACJL Kano. Then you see the section 55 subsection 3 of the Police Act 2020. So when can a search warrant be issued or executed? A search warrant can be issued or executed on any day, including Sundays and public holiday. So it can be issued, it can be executed at any time. Sunday, public holidays, Saturdays, anytime. Now, ACJL, section 108 sub 1 of ACJL gave a time constraint. So any day, including Sundays and public holidays, but in Lagos, that any day is between the hour of 5 a.m. and 8 p.m. That is only Lagos. However, ACJA and Kano, there is no time constraint. So even in the midnight, you can come and search your premises with a search warrant. Now, in a search warrant here, the things that are to be obtained are written down in the search warrant. And the people that are searching, they do not have any business with seizing anything that is not in the search warrant. However, when they now come across incriminating evidence and something they think is okay because of the offense that they're investigating, something that is helpful to them to prosecute the crime, and they come across it while searching, but that particular thing was not written in the search warrant, what do you think would happen? They are expected to seize it. Now, supposing they seize it yeah, can they tender it in court as evidence? Because in search warrant, they said seize this. They did not talk about that particular one. And you seized that one they did not talk about. Can you tender it in court? You want the answer? Yes, you can. You can tender it in court if it is relevant to the facts. Unless the desirability of tendering it is being outweighed by the undesirability of tendering it. You see that in section 14 of the Evidence Act. So if it is not needed, if it is not desirable to admit it, why do you want to tender it? So section 14 says, unless the desirability of tendering it is outweighed by the undesirability of tendering it. So section 15 now states what would make it desirable, like what would make the desirability to outweigh the undesirability. I hope you understand. So read section 14 and section 15 for proper understanding. So if you want to go outside jurisdiction to execute a search warrant, you first have to apply to the court within the jurisdiction of that particular place you want to execute it, and you now act under its direction. Now we're done with search of premises. We will now look at search of things. Now it's very simple. If you want to search things, it depends on what you want to search, based on whether or not you would get a warrant to search those things. For example, if you want to search a vehicle on the road, you do not need a search warrant. You want to search a bag, you do not need a search warrant. However, if you want to search an aircraft or a vessel, a search warrant is needed. I thought I would do everything on this particular video, but this one is now very long. So the next time I come, we'll talk about arrest, then we'll talk about constitutional rights of a person that is being arrested. So please take care of yourself.